Hello everyone, your immigration lawyer Mustafa Satin back with another video. It's going to be another one of those general reference videos. Today's topic is affirmative asylum process. In other words, asylum application before the USCIS, where you start the process by filing an I-589 form. I have a diagram here that I'm going to be completing as we go. I find this very helpful. I usually actually use this during my consultations to help my clients explain the process. Hopefully this will give you a sense of predictability in the usual chaos that is USCIS. With that said, here we go. Okay, so let's see. The process starts with filing the I-589 application. That's where the starting point is. And the next step is scheduling of the interview. So about scheduling of the interview, the usual process is, the method is last in, first out. So since early 2019, the last asylum application that was filed is supposed to be interviewed first. So because of that, we have experienced very fast interviews upon filing of the I-589. That is, until it was COVID. So when COVID hit, everyone was stuck here because USCIS's capacity to adjudicate asylum applications dropped drastically with officers working from home. So we started to see, if I were to put it in context, to put it simply, before scheduled, we used to see 3 weeks of appointment times, and interviews used to be 3 weeks from the appointment notice. Nowadays, it's not very much so. Hopefully, it will go back to that. But for now, for reference, this is what we should stick with. At the interview, asylum officer asks the question. I'm not going to get into specifics of an asylum interview, which is probably another video. But at the end of the interview, the officer decides, come up with a decision to either grant asylum or, depending on your status, other immigration status. There are 2 scenarios here, which we're going to talk about. So, next point is decision. When is the decision? That's a very good question. Again, prior to COVID, the officers were supposed to be done with their decisions within 1 week of the interview. And the individual who attended the interview were supposed to pick up the decision within just 2 weeks in person. Nowadays, with the COVID, unfortunately, this standard became mailing out the decision. So let's say you had your interview at a certain point, and the decision could be, unfortunately, months from that time. But let's talk about what happens at the time of the decision. What are the outcomes? So we have the decision. It could be the happy result, of course, approval, asylum grant. Let's put that down. Asylum approval. In other words, grant. Asylum grant is a dream come true. First of all, it is permanent status, very much alike to permanent residency. And upon 1 year being an asylee, you can file for permanent residency by filing an I-489 application. And then 4 years upon getting your green card, you apply for citizenship. Let's talk about the not favorable outcome. Let's see what happens. So depending on if you're in status, if you have another immigration status or not, you can see here, there are 2 outcomes. First one is being in status. So if you have another immigration status, USCIS has to decide on your application, and if they're not going to grant it, they would have to deny. And to deny, they first come up with notice of intent to deny. That is a preliminary decision in which USCIS explains the reasoning behind why they will be denying the application. And you get a chance to reply to this notice of intent to deny, and if your reply is strong enough, you're lucky, USCIS should be able to retract, the notice of intent to deny and issue a grant. So there is a possibility of going back to approval or grant from notice of intent to deny. If that doesn't happen, USCIS sticks with its decision, and unfortunately you are denied. What about the other scenario? So if you are not in status, you are referred to immigration court. Immigration court is basically removal proceedings. If someone is not in a valid immigration status, USCIS, which is a part of Department of Homeland Security, becomes the prosecutor of someone's removal from this country. They place this individual in removal proceedings, and DHS, specifically ICE attorneys, Office of Principal Legal Advisor, becomes the prosecutor in your case for you to be removed from the United States. So referral to immigration court, denial. One thing I want to add is, it's an important point here. Let's say someone has an immigration status, but it's not for a long time. And because of that status, let's say they applied when they were in 6 months B1 or B2 status, and they got their denial before the 6 months end. But right after the denial, their status expired, and they want to apply for asylum again because by law, USCIS's decision on the asylum is not final. USCIS cannot decide on this. It has to be decided by the immigration court. And what happens is they reapply for asylum, but instead of going through this process, USCIS automatically refers to court. This is what I want to talk about. Hopefully it is helpful, beneficial. I've got really positive feedback from my clients. So thank you for listening. Please like the video and share with people who you think would be interested and benefit. Thank you. Have a good one.